Injunctions in the family courts. First of all, I'm just going to go through the agenda of the issues that I'm going to cover today. But first of all, I'm just going to talk a little bit about me and why I'm doing this course and the knowledge I have that allows me to do this. Then I'm going to talk about what is an injunction. There are actually two types. There's a prohibitive steps order and a non-molestation order, which ties in as well with an occupation order. So they are the main types of injunction, but obviously I will talk about what the injunction is and what the different orders are for. Dealing with an application that is made either against you or by you. So first of all, just talking about me, I joined the army at 16. I trained in building design and I worked in architecture for about 25 years. In 2001, 2002, I got divorced. My ex-wife wouldn't let me see the children for more than an hour a month. So I took her to court and I was successful in getting a court order. I was then asked to be a Mackenzie friend for somebody. I didn't know what one was at the time. So I went to court with him as his Mackenzie. And then I was asked by other people to help them. And it grew and grew and grew from there. And I started to pick up experience. And then I found that I actually had an interest in law. And I did a graduate diploma in law, which is equivalent to a law degree. And I passed that, much to my surprise. And I then did the bar vocational course, which is the course to become a barrister. It's now called the BPTC, but I did that course over a 2-year distance learning, 2-year part-time course. And I was then called to the bar in 2010 as a barrister. I continued to work as a Mackenzie friend. I have never worked as a barrister. I'm a non-practicing barrister. So my current situation is that a few years ago, I retired to France, and the idea was I was going to retire, but retiring is boring, and I wanted to do things. So I've continued with offering advice. I've continued with helping people with statements and applications. I don't go to court. Generally, I don't go to court. And I am also running training courses and doing lectures online. And I enjoy doing all of that, and I will continue to do so. Throughout this lecture and every other lecture that I do, gender is mentioned a lot. Mum, dad, him and her, husband and wife. And the situation typically in court is that the children are with mum, dad is trying to see them, or mum is making a non-molestation application or occupation order against dad. I don't think in all of my years in working in court, which have been almost 20 years now, I have ever done a non-molestation order for a man. I've only ever done them for women, or I've only ever fought them. I've fought to get them, and I've fought to stop them from both sides. I do understand that gender or the gender roles can be reversed, and there are lots of mothers who don't see their children, mothers who are prevented from seeing their children, and there may well be mothers who are fighting a non-molestation order against them. So I make no bones about it. The gender works both sides. So what is an injunction? It is a judicial order restraining a person from beginning or continuing an action threatening or invading the legal right of another or compelling a person to carry out a certain act. So it is essentially, it's an order that will stop you from doing something that threatens or invades the legal right of another person. So that makes more sense. It's if you are doing something that is affecting someone's rights and you shouldn't be doing that, this order will stop you. It will stop you from either starting it or stop you from carrying on. It will also stop you from getting somebody else to carry out something, to do the same thing. Now, when you think about a standard court order, that is in itself a type of injunction, because a standard court order may say that dad will see his children alternate weekends. That is preventing him from seeing them during the week. If it isn't in the order, he isn't necessarily going to see them unless they can agree to something. So a standard order, in a way, can work as an injunction. You then very often will have, particularly in the early stages of proceedings, a prohibitive steps order. Now, that is something that you can apply for that will prohibit someone from doing something. And I'll go on to explain that further in a minute. And you then have a non-molestation order. Now, that is an order which is preventing you effectively from molesting the other person. It isn't just molesting physically, there's harassment, intimidation, pester, all those sorts of things, even communicating. And very often tied in with that order, because if you are living in the same house as somebody who isn't allowed to threaten you or cause you harm, and they have threatened you and caused you harm, that's not going to be very comfortable for you. So the court can make an order restricting who lives in a certain property. And that is known as an occupation order. Now, it can remove somebody from the property entirely, or it can restrict their use or movement in that property. And it's not uncommon to have a situation where one of you is able to use the kitchen between certain hours and the other one in different hours, just so that the two of you never meet. So going back to the prohibitive steps order, it prevents a person from carrying out an action. So the order will say you are prohibited from doing something, taking a certain step. A typical one is if there is an application to remove children from the jurisdiction. So the jurisdiction of the court is England and Wales, as far as I deal with. And if you wanted to go to Scotland, you are going out of the jurisdiction. It's not the same issue necessarily as if you're going to go to Australia, but it is still an issue. And in the early stages, quite often in a first application, somebody, particularly if they are married to someone from another country, for example, Australia, you've married an Australian girl, you've got children, you separate, there is a chance that she will want to go back to Australia. Now, until the court has dealt with the case, you don't want that to happen. You don't want her to just disappear and go off to Australia and then the court can't deal with it, all of those things. So when you make your application, you would ask for a prohibitive steps order to prevent removal from the jurisdiction, certainly while these proceedings are going on. You may want them to prevent her from ever going to Australia and taking the children with her, but that isn't quite so straightforward or sensible necessarily. If you lived, for example, in the south of England and your ex says, I'm going to take the children to Northumberland, it's still in England, so you're not out of the jurisdiction. The court cannot prevent her or him from moving to Northumberland, but they can prevent the children from moving. So they can make an order that prohibits her, in that example, from removing the children from school. Now, she can't then go to Northumberland and still take the children to school in maybe Sussex or Cornwall. It's ridiculous. So it would prevent that from happening, usually while the court proceedings are going on. And at the end of the court proceedings, a final decision is made, which may allow her to go and move to Northumberland. And then obviously you would take the children there and they would go to a different school. You can have an order that prohibits a child from being removed from the resident parent. Now, you very often, as proceedings commence, you'll have the husband and the wife, and the husband may say, I'm going to go and pick the children up from school because you're not letting me see them. So I'll just step in and take them myself. In that instance, the mother can get an order to prevent him from removing them from her care or control. Now, her care is when they're with her. Her control is when she has left them with somebody else. So she can leave them with the school. She could leave them with her parents, and he cannot take the children. Obviously, these things work in reverse, and it could be the other way around. But this is quite a common prohibitive steps order that would be asked for. You can have a prohibitive order that prohibits you from consuming alcohol or taking drugs, particularly while you have the children with you. It's going to be of no value to the children whatsoever, and the children are really the court's only, or certainly the main consideration. There's no point the children being with you if you're drunk or if you're stoned on drugs. It's ridiculous, and you can't take care of them properly anyway. So the court will prohibit you from doing that. So if you're an alcoholic or you are a heavy drug taker or even just taking drugs, if they know about it, they can make an order preventing you from consuming alcohol or taking drugs in the 24 hours before and during your time with the children. And that's quite reasonable and sensible. It can also prevent a person coming in contact with a child. I've had a situation where the mother had a cousin who used to see the children, and he was on the sex offenders register. And the father didn't want this cousin coming in contact with the children. And that's fair enough, and it's reasonable, and the court can make an order for that. You can also, if the children have been taken by the mother, it's so easy to fall into this trap of using mother and father, but the children have been taken by the mother to live with her new boyfriend, who is a known violent person who has beaten up a previous partner, perhaps. You don't want your children being there. And you can get an order, providing that you can show that this person is violent, you can get an order to prevent that person coming anywhere near your children. All of these things are safe for children. So the court will quite happily make orders that are safe for children. I had a case where the father was prohibited from cutting his children's hair. I don't know quite what had gone on. Maybe he'd given them a skinhead haircut when he shouldn't have done it. I really don't know. But I have seen that order. I was quite surprised by it. But it's to prohibit silly behaviour, and that is also quite reasonable. So to get a prohibitive steps order, when you make your application on the C100, you would list it on there. So on the front page, it asks you what kind of order you're looking for, and you have a child arrangement order, prohibitive steps order, and a specific issue order. You would just tick the box for prohibitive step. You can also tick the child arrangement box, and you could tick the special issue order on the same form. You could have 1, 2, or 3 of them. Really doesn't matter. It depends on your situation. But the prohibitive steps order, you ask for it on that application. You explain why it's necessary to have this order. It is often a temporary stop, and it may be that if you said to the court, I spoke to my ex yesterday, she said that she's going to catch a flight to Australia tomorrow, can I have an order to prevent her? The court should, and very often would, make an order immediately to stop that from happening. Then they will hear her side of the story. They will then deal with the case and then decide whether she can go or whether she can't go. The non-molestation order is to prevent a person from carrying out an action. Very often, and I've listed a couple of these, not to threaten somebody, not to pester them, not to intimidate, not to harass, not to attend a certain address. Now, it may be that the person who's applying for the order is scared, doesn't want them coming to the house and upsetting them, causing them even further harm. If you can show that these things are a risk, then the court will include these things in an order. So not to attend an address, it's not unreasonable to have that in an order. Not to be in the vicinity. So it may be that you wouldn't want them to come in the vicinity of the school because they have been going up to the school gates and trying to talk to the children through the railings. The children might be scared. The teachers come over. He's had a go at the teachers. It wouldn't be beyond the realms of possibilities to get an order that he's not allowed to go near the school because it upsets the children and causes problems. So all of these things can be done. And then you would quite often, it will have not to communicate with the person that you are causing the harm to, other than to do with making arrangements for contact. Because if you are seeing your children, nobody wants you to not be able to make arrangements to see them. So they will say you're not to communicate with her, so you're not allowed to send her text messages threatening or intimidating her or any of those things, but you can talk to her about contact. If you send messages that are not about contact and about something else, then she can go back to court, and she could even have the order removed that you can only talk to her about contacts. That could be removed. If you mess about with it and you overstep the mark, you will be restricted even further. Now, the occupation order, as I've said, it prevents a person from occupying all or parts of a house. And I suppose it doesn't need to be a house. It could be a flat, could be a mobile home, could be anything, but anywhere that you are occupying. It can tell you to leave the address immediately. You may be given an hour to collect your belongings and then go, or if it is a serious risk, just to go immediately, and then your belongings will be dealt with later on. It would have a clause in there that you're not to return to that address. So having been removed, they obviously don't want you coming back to it the next day or something. The non-molestation order and occupation order, they are on the same form. So they do go together in these things, and it's the form FL 401. It's a Family Law Act form, but that makes no difference to you. It's just a form. It goes to the family court. For a non-molestation order, you need to explain why the behaviour is undesirable. That's not difficult to establish. That if somebody's punching you in the face, that's undesirable. But you do need to explain the things that are going on and why they're causing harm. Again, explaining why that why that behaviour is harmful, not necessarily just undesirable, but also harmful. You need to get an occupation order. You need to explain why the housing is necessary, that you can't go and live somewhere else. Very often, particularly with children, the children need to go to school. The children need to be in their bedrooms because that's their safe place. It's where their toys are. It's where their clothes are. It's where they feel at home. So it's important for the children to be there. And that can very often give the mother the reason to come back into the house and the father to be removed. Right or wrong, I'm not judging that. It's just this is how it is. In order to get an occupation order, you need ideally to explain where the other person can live. The court are not going to be happy at just saying to somebody, you can't go in that house. You might end up living on the streets. And that's not an ideal situation for the court. And if you are living on the streets, and I had a client not long ago who was, then the court can order that you share the house, but you keep away from each other and don't cause problems. It must be a nightmare living under those conditions, but if you've got nowhere else to go, you have to live somewhere. Right, now, why this process is unfair for the applicant. So the person applying to get this, it can be very unfair for them. They will be very often emotional, frightened, fearful of repercussions. What's the other person going to do to me if I get them kicked out of the house? I'm frightened of even doing anything. And people who live with domestic abuse are going to be worried about dealing with it because they know that unless they are protected, it's going to get even worse for them. So if you are helping somebody, or if you are thinking of doing this, or even speaking to somebody about it, you need to understand their position. You can't just say you need to just man up and deal with this. It's easy for you to say you're not in that position. It may be difficult for them to explain to the court why they need this protection. And if they don't get it right and they fluff it up, they may not get the order that they're looking for. And again, this is very often an individual person who has never been to court, isn't necessarily capable of expressing themselves as well as the court would expect. The court are used to hearing from solicitors and barristers and highly intelligent people. It may be that if you're helping somebody, or even you yourself, bearing in mind you're emotional and frightened, you're not going to be thinking clearly, and you're not going to be able to talk particularly clearly. What if nobody believes me? If I make this application, I go into court and they say, no, sorry, we don't believe you. The fact is, if you can go in there and you can explain to the judge the issues and your concerns and why you are at harm, they will make an order. Pretty much, they will make an order. It isn't a case of whether they believe you or not. They've got your side of the story, and it might well be true. We'd better make an order. But people will worry that people won't believe them, and that can put them off. If they go to court and they lose, what's going to happen to them? What's going to happen to the children? Now, all of this can put somebody off even applying. But I would advise that if you are living in a situation that you are frightened and scared and you are being abused, you should do something about it. You should get some help. You could talk to me. You could talk to lots of other Mackenzie friends. Solicitors will give legal aid very often in this sort of situation, and deal with it as long as you can and as long as you're comfortable with dealing with it. And sometimes you need to take that step. But you should never, and nobody should ever live with abuse. And then some people will say, well, what's going to happen to my partner if I win? I still love him. The fact that he beats me up occasionally, I can put up with. And I've had clients like that. I had a lady who'd put up with it for 20 years, and her husband would regularly beat her and force himself on her, and all of those things happened for a very long time. She could put up with that. But then he started on the children, so she had to do something about it. So that was a tipping point for her. The reality of that one, she didn't actually love her husband, so never had. But people do still love the person who is abusing them and don't want any harm to come to them. That's just one of those things. Right, now the person who's on the other end of this, it's unfair on them as well. They also can be emotional, frightened, and fearful of repercussions. The very first thing they may know, as they're happily living their life, going about their business, all of a sudden they are met by someone who puts an order in their hand and says, you are not allowed to go anywhere near your home anymore. For someone who has never done anything wrong, you can still get that order. And how upsetting is that you can't even go home? You can't go and see your children. You can't go and see your wife, and you've never done anything wrong. So that can be very, very unfair. In the same way that it's difficult for the person applying for the order to explain themselves, it can be difficult for you to explain yourself when you're trying to defend yourself against this. Maybe no one's going to believe you. You can say, look, I haven't done this, but she might be more persuasive than you. Who knows? But these are concerns that you would have. And what will happen to you or the children if you lose? Will you ever see your children again? What will happen to my partner if I win? If the courts say, well, we don't believe that any of these allegations have been made, you can now go back in the house. What's going to happen with her? Where's she going to go? Is she going to stay there? It's all unknown. And there's nothing worse than the unknown. So typically, why this process is unfair on everybody, again, typically, legal aid is available for the applicant. If you are a victim of abuse, as long as you fall into the right categories for income, then you will get legal aid. And if you get legal aid, you have a solicitor and you'll have a barrister at the hearing. You don't need to go in there worrying about whether anyone's going to believe you or not and whether you can get your story out. You've got a professional person doing it for you. It may be that I don't want to refer to mine. If I said that the mother makes an application against the father, it might be that the father is a victim of abuse. And then that's unfair, but he doesn't get the opportunity to make his arguments in the same way that she has. She's there first. She's got the legal aid. She's flying. And he is going to get the order very quickly. And it's only later on, much later on, when the court consider everything and look at it, that it may turn out that actually he was the victim. But that's a lot further down the line. He's been out of his house for 6 months. He's not seen his children for 6 months. None of that is fair on him. How do you deal with the courts? People who work in normal jobs, working in a warehouse, an electrician, a plumber, they don't go to court. They don't deal with these things. And you may see on television courtroom dramas, but the real life is nothing like that at all. And if you don't know how to deal with it, how can you deal with it? It's all unknown. Where am I going to live? I've just been given an order that I can't even go home. I can't go and pick up my bank card. I can't get some cash that I've got in the drawer. I can't say goodbye to the children. I'm just gone. It's not good at all. And what happens if you go through that whole process and you pay for a solicitor and you could pay £10,000, £15,000 and still lose? Because the court will make a decision based not necessarily on the facts of the abuse, but on other reasons. How you present yourself in court. There may be no proof and no evidence whatsoever, but in court, you may get so wound up at the whole thing that you become aggressive. And then the judge is going to look at you and think, well, you probably did do this because you can become quite aggressive. It's all unfair. And then you've got this in, when will I see my children again? I went through a period of 6 months without seeing my children, and it was a very, very painful thing to do. And it can be more than 6 months. I've got someone that I'm helping at the moment. He hasn't seen his children for 2 years. And it's an awful thing to go through. And people who block contact and make allegations in order to prevent things, contact going on, just because they don't like the other person, they're party to all of that. And it is a very, very unfair thing. And the court is trying to unravel it, but the court has its own issues, and it can all take time, and it can be difficult to prove your innocence or guilt of the other person. So how is your case actually going to be decided once you've gone to court? Initially, it's very common that you'll get a temporary order. So it will, if you go to court today and allege all of these things that have happened to you, you get an order pretty much immediately. Within 2 weeks, there will be a second hearing where the other side is there to give their side of the story, and maybe that order will be taken away. But you can pretty easily get that first order. You've then got to do a bit more work to keep it once it gets challenged. If at that hearing 2 weeks later, and it doesn't have to be 2 weeks, it has to be within 2 weeks. If you cannot reach any agreement over what's gone on, then the court will ask you to provide a statement and a schedule of allegations, and then the other side will respond to that statement and they'll respond to the schedule of allegations. And then the court will examine the evidence. Now, I've put a question mark on this because this is another unfair part of this process. If you are in a magistrate's court, you are not going to get the same legal scrutiny as you would if you were in with a district judge or a circuit judge. Most court cases begin with magistrates, and you have the three magistrates who will listen to your case. They may be experienced, and I certainly wouldn't say that all magistrates are useless, but a lot of magistrates I've seen have been absolutely useless at what they're doing. Some of them have been very, very good, but the majority have not been very good at all. And they will listen to something, and I had an impression that if you were in court and one of the sides had a barrister representing them, the magistrates would tend to go with what the barrister said. Barristers are very, very clever at getting the attention of the court and persuading the court that they must do something. That's their job. They do that every single day of the week. And they're very, very good at it. Some of them have been doing it for 20 years, even longer than that. And it's difficult for a magistrate who isn't that confident and isn't that well versed in this whole process to be persuaded by them that they should do something. You sat there on your own trying to deal with this against this person and against this magistrate. What are your chances? Can that be fair? Are they looking at the evidence and looking at the evidence sensibly? There's a question mark that I would put on that. There's also a question mark there because some of the evidence is there can be a lot of it, but not actually any evidence at all. Most things, I know that doesn't make sense, but I'm just trying to explain it. Most things happen behind closed doors and there is no evidence, but little bits and pieces may come in that a neighbour's heard some shouting. In the court, you may get angry and frustrated at this whole process and get really annoyed and edgy and maybe start arguing, start banging things down on the table. And they're going to look at you and think, well, maybe this is all true then, even with no evidence. So you certainly have to conduct yourself well in the courtroom, but these cases are not necessarily decided on evidence. The court will then, having heard the evidence and seen the evidence, they will decide whether the allegations are true or not true. There's no middle ground, and in life there is a lot of middle ground. You will have one person who will either exaggerate it or see it through their own eyes, obviously, and the other person who may want to minimize something that's happened, but again, they're seeing it through their own eyes. And those parties may well see the same thing and have completely different views about what happened. And there are lots of things that I believe that you would have in a relationship where you may come home from work and you say, well, what have you been doing all day? As a joke. And you may both laugh about it. But when you go to court, well, every day that he came home from work, he said, well, what have you been doing all day? And it was said in a nasty way, and I was frightened, and I used to dread him coming home from work. So these things build up, not necessarily how it was lived in real life, but if you are trying to exaggerate it to make your point, and the other side's trying to minimize it, those things happen. And things that were perfectly normal to you do and can become exaggerated. It can also be the case that you go through the whole court process and it was all done, none of it was true anyway, but it's still found against you because of other reasons. Now, if the court decide that none of it is true and we're not going to make an order against you, nothing happens to the person who's made the allegations. They don't get viewed badly. They don't get criticised. They don't get fined. They receive no punishment for that at all. It may have caused you to not see your children for 2 years, but there's no repercussions on them. And there's a fair reason for that, in that if you did punish somebody because they don't get their story straight in court and we don't believe them, what happens to other people who are worried about going to court and their story not being believed? They're not going to touch it with a barge pole, but they may genuinely need the protection. So you won't be punished if you make false allegations. There's a huge unfairness, but I don't see the answer to that other than continuing as things are. If the allegations are true and the court decides that, yes, you have been violent and abusive and controlling and all of those things, then you will probably have to go on a domestic violence perpetrators program. It has various things that it's called. Domestic violence IP, DVIP, intervention program, domestic violence intervention program. So you can go on those courses. Sometimes they take 2, 3, 6 months. And it's only once you're on the course and working through it that you may begin to see your children again. But for some people, particularly if they have been found that they have done something that they haven't done and they know they haven't done it, they cannot go on this course unless they admit that they have done it, because you cannot be remorseful for having done something if you don't recognize it as being bad. So if you have beaten your wife, you can't go on the course unless you say, yes, I did beat my wife, and I'm sorry, and I know I shouldn't have done it, and you're now going to teach me how to behave in a different way. If you can't see it was wrong in the first place, you can't go on the course. Now, if the court has got it wrong and you've not defended yourself very well, and lots of people don't defend themselves very well, they make a complete mess of it because they think, well, the truth's going to come out, but you've got to fight for it. It isn't that straightforward. So you end up with an order that's not true, and you then can't do the course. Then you can't see your children, and that's it. You just don't see your children again. Now, further information about this, I have a lecture. I do a lecture every month. This is one of the lectures. They're entirely free. You can sign up to have an invitation to an online session for the lecture. Next month on 10th of August, I'm doing a lecture on divorce, and it is how to pretty much get a guaranteed divorce. It's not a difficult process, and I will explain that whole process to you. I also do training courses, and I have a course on injunctions, which is what we've covered today, in full detail. So if you are making an application or you're defending yourself against an application, I will cover, I hope, everything that you would need in order to do that. So that's on the 22nd of August. If you want a ticket for the training course on injunctions, that's the address, Ticket Taylor Events, Simon-Walland-Family-Law, and the cost is £80. And as I say, I will go through everything. I will give you examples of the documents you need and discuss how to challenge the allegations made against you when you get to court. The other thing that I have is the Simon-Walland-Family-Law Academy. It's an online school or academy with all of the lectures and all of the training courses, all recorded and put on there for you to watch. So the courses, there is a fee to watch them online. The lectures, there isn't. They are free. And there are some other informative lectures on there that are free, and other things that, again, are free, and things that you do pay for. But there's a range of things there. And the address for that is Simon-Walland-Family-Law, teachable.com, and then courses. Now, I hope that this has been interesting to you and that you've learnt something. You are welcome to come anytime you want on one of the free monthly lectures. Obviously, welcome to join a training course, or you're welcome to go onto the academy and purchase a course there. The courses that I do, the training courses and the academy, are far, far more detailed than I've been able to cover today. They will last for 4 hours as opposed to 20 minutes. But hopefully you've enjoyed it, and I hope to talk to you again soon.